Okay, this section is about conduct and speech. And this is the concept that there are certain situations where actions that you take or things that you do can actually be protected by the First Amendment as a form of expression. In other words, you're doing something as a way of expressing yourself, and that is protected by the First Amendment. And this first slide gives a few general examples of that. You know, the idea of a silent protest, picketing, burning an American flag, even in some cases nude or erotic dancing. These are all things that potentially could be considered forms of expression and thus could be potentially protected by the First Amendment. However, as with anything in this class, it's not that simple. We have to actually look at balancing once again, and we have to basically balance a person's right to express themselves through actions with the ways that it might affect other people or other things. And so that becomes the central challenge to this type of discussion. But first of all, let's first consider that there are three kinds of conduct for our purposes. First of all, there's conduct with no communicative value. So you might know that the proper way to dispose of an American flag, or at least one of the proper ways, is to burn it. So if I have this American flag that, I've been flying outside my house for 20 years and it's all torn and tattered and I basically want to get rid of it and replace it, I might, in order to properly dispose of it, put it in a barrel in my backyard, put it down there in the barrel, pour some gas on it, light it on fire, and burn it. I don't invite anybody over. I don't, make a big deal of it. I don't say, hey, look at me, I'm burning the American flag. I just do it, and it has no communicative value. So then we also have purely communicative conduct. So this would be if I get my new American flag and I put it outside in front of my house. So I hang it on my porch. That is a purely communicative action. By flying that flag, people might not know exactly what I'm saying, but they can guess that, I love my country, I support the troops, whatever. But that is, something that is just purely communicative. Then the third kind is where we mix these, where we have both communicative and non-communicative aspects. And the book gives a pretty good example of this. This would be, for example, if I disagree with my neighbor's politics and I just get so angry at him and I think that his views are destroying the country, and so I take the American flag and I tie it up in a ball and I dip it in gasoline and I throw it on his front porch so that it can burn on his front porch. Well, okay, that has communicative value from my standpoint, but it also has this non-communicative aspect to it as well, which is this idea that, well, I'm going to probably damage his porch with burn marks, or I might even catch his porch on fire. In fact, I might even catch his entire house on fire. I might even, kill him by doing this. So this is the kind of place where conduct goes beyond being purely communicative and has both of these elements in it. Not surprisingly, this third kind of conduct is going to be the kind that is least protected by the First Amendment, at least compared to the second kind. The first kind, generally, we don't care if it's protected by the First Amendment, because if I'm not trying to communicate anything, I don't care. But we're basically sort of looking at the difference between conduct that is purely communicative and that has both communicative and non-communicative. So, the first question that the court asks about this when they're trying to determine whether something is protected as expression or not is the conduct expressive? And in this case, we have to consider both the intent to express something and the likelihood that people would understand. So in other words, there had to be an intent on my part to express something, and there had to be likelihood that people would understand. And people don't have to understand exactly what I'm trying to communicate, but they sort of have to understand the general gist of it. So, for example, if I burn an American flag, or if I tear up an American flag, or I tear up pictures of the president, or I take an American flag and I dip it in goat's blood, these are all kinds of things where, if you saw somebody doing that, you might not know exactly what they're doing, but, you'd kind of get an idea that they're against something that this country or that this president is doing. So the idea there is that, again, people aren't going to necessarily understand exactly what's going on, but they'll understand that something is being communicated. So if the answer to this first question is no, so if the conduct isn't expressive, then if the answer is no, then there's no First Amendment question, which means the government can regulate whatever it is we're talking about. However, if the answer to this question is yes, we then go on to ask the next question. And that question is the expressive conduct protected? And we have two very important cases to talk about here, which will help us kind of get an idea of how it is decided whether something is protected or not. Those two cases are United States versus O'Brien from 1968 and Texas versus Johnson from 1989. So United States versus O'Brien involved a guy during the Vietnam War who burned his draft card. And just so that everybody's on the same page here, in the 60s, during the Vietnam War, there was a draft, which essentially meant that when you were an 18-year-old male, when you graduated from high school, you had to go and register with the Selective Service System. They gave you this little identification card, and once you did that, it was conceivable that you could be drafted, which basically meant that you were forced to go into the military and go fight in Vietnam. The government agency that handled doing draft was the Selective Service System. So, the Selective Service System had a law on the books that basically made it illegal to burn or to destroy or to otherwise, damage your draft card. Now, and once again, in today's world, I know it's kind of a little hard to grasp this, but you have to put yourselves back in the 60s before we really had computers and databases that were as mainstream as they are today. And, it's hard to imagine that the government needed you to keep this card in order that they could run the Selective Service System. But at that time, it was true. So the only way the government could successfully run the Selective Service System was if people didn't burn their draft cards or didn't damage them or do other kind of stuff to them. So that's the law that O'Brien was prosecuted under. Texas versus Johnson involved a guy who burned an American flag outside the Republican National Convention during one of the years when it was held in Texas. And at the time, Texas had a law against burning the American flag, and he was prosecuted under that law. So both of these cases reached the Supreme Court. However, there were two different decisions made. In the case of O'Brien, the court upheld the federal law that prohibited people from burning or mutilating or, throwing away their draft cards. In the Texas versus Johnson case, the Supreme Court said that the Texas law against flag burning was unconstitutional. And so, how do we determine what is the difference between these two cases? Well, it boils down to this. We have to look at what was the government intending to do by its regulation. So, in the case of the draft card, we've already talked about how the intent there was not to suppress people's free speech. It was basically because we needed everybody to have these cards, otherwise we couldn't run the military. So the regulation wasn't aimed at keeping you from expressing yourself, keeping you from protesting this war or anything like that. The regulation was basically aimed at making it so that we could run this system. Now, in the Johnson case, I mean, obviously, if you pass a law against burning the American flag, that is purely content-based, where you're clearly basically saying that I don't want you doing this because I don't like what it communicates. Okay? And so it's very important that you understand that difference. Okay, in the O'Brien case, the government didn't care about what you were communicating, or anything like that. They basically just needed everybody to have these cards so that we can run our program. In flag burning, though, it's clearly the opposite, where, essentially that is a content-based regulation. So, if the regulation is aimed at the expressive content, which was what a flag burning statute is, then we apply what is called strict scrutiny. And strict scrutiny, to sum it up, essentially means that the burden is on the government to prove that it has to have a really, really good reason for doing this. And it's going to be not impossible, but fairly close to impossible for the government to prove that. However, if the regulation isn't aimed at the expressive conduct itself, then we apply what is called intermediate scrutiny, which is also called the O'Brien test. So the O'Brien test, we ask these 4 questions, and the answer to all 4 questions has to be yes in order for the government to be justified in regulating conduct. The first, is the regulation within the constitutional power of the government? So that's fairly, straightforward. In the O'Brien case, yes, the government does have a constitutional right to raise and to support an army. And so that is part of what the selective service system did and does. And so yes, the answer was yes in O'Brien. Does the regulation further an important or substantial government interest? Once again, in the O'Brien case, the answer was yes, because draft cards were a vital part of having this system be functional. Third, is the government interest unrelated to the suppression of free expression? In O'Brien, once again, the answer was yes, because, once again, the government wasn't trying to, they didn't want you not burning your card to protest, they wanted you not burning your card so that you would still have the card. And then finally, we say, is the incidental restriction of expression no greater than essential? So in the case of O'Brien, once again, the court said that yes, it was. So all of this sort of comes down to this idea of, if the government is aiming at actually restricting expression, it's going to be much harder for them to enact a law than it is if they enact some sort of law and somehow incidentally it restricts a little bit of free expression. So that's kind of what the whole O'Brien test comes down to. Okay, so let's talk a little bit more about flag burning. Congress and a lot of others weren't happy after the Johnson ruling. There have been efforts afoot to put a constitutional amendment in to basically prohibit flag burning, because essentially where we stand now is the Supreme Court has said that flag burning statutes are unconstitutional. Okay, so we know that nobody can pass a flag burning statute. So that means states can't have one, Congress can't pass one, a city can't have one. So the only way that we as a country are going to restrict the burning of the American flag is if we actually put it in the Constitution. So there have been some efforts in this direction. Generally speaking, Republicans, this tends to be something Republicans are more enthusiastic about than Democrats. If we get a more Republican House of Representatives, and if the Senate turns over to the Republicans at some point, there might be more talk of this, and especially too if we at some point get, Republican Congress, Senate, and a president. This is something that could be put into action. But essentially, that's kind of where we stand now. Like where we stand right now is you can't pass a law against flag burning because the Supreme Court has said that it's unconstitutional to do so. All right, nude dancing relatively quickly. I mean, dancing is clearly a form of expression. Nude dancing is also a form of expression, and I don't think anybody would argue that, nude dancing isn't expressing something and that the people that are sitting around watching it are getting it. So there's no question there. However, this is another one of those cases, and we'll come to see it when we talk about obscenity too, where the courts are just a little bit too queasy to actually give it full protection. So what they end up doing is they end up kind of like hemming and hawing and kind of coming up with these sort of like vague reasons why it might be dangerous and it might hurt kids, and we don't want to do all these kind of things, but they really never actually come up with a good reason under their own standards why it shouldn't be protected. And so I guess I'm not going to talk about any particular cases there, other than that there was a case that involved a guy in Erie, Pennsylvania, who ran a nude dance club. He challenged a city ordinance that made nude dancing illegal. It reached the Supreme Court, and the Supreme Court, in a pretty narrow decision, decided against the owner of the nude dance club. And, again, when I teach the class in person, sometimes I talk more about this, and I actually show some quotes from the case, which you can actually read in the book. But it sort of gets at this whole thing of like, if you read the court decisions, some of the justices are really just sort of tying themselves in knots in an effort not to grant protection to nude dancing. So where it comes down with nude dancing is it's okay for cities to prohibit nude dancing in certain cases, as long as it doesn't get to be like too restrictive. Okay, and then let's talk about this concept of hate speech. And hate speech is almost sort of the opposite of what we've been talking about, because in hate speech, we're kind of talking about speech as conduct. And what we mean here is words that are so powerful that they actually are almost like punching you in the face. For that reason, hate speech is also referred to as fighting words. So these are the kind of words that attack individuals or groups because of their race or their ethnic background or their religion, their gender, their sexual preference. I mean, we all know what these kind of words and what these kind of sayings are. There are very few people that think that hate speech has any real value, but what do you do about it? Abolishing the language isn't going to change the way that people think. So just by saying, hey, you're not allowed to use this word, you're not allowed to use this word, you're not allowed to use this word, that's not going to change how people think. And another thing, one of the themes of this class also is that, the true test of how much you believe in the First Amendment is how much you think it protects something that you find repulsive. So, once again, the First Amendment isn't there to protect birds and flowers and things that everybody loves. The First Amendment is there to protect things that a lot of people might not like. So, a couple of seminal cases here. We have Chaplinsky versus New Hampshire, which involved Chaplinsky, who was a Jehovah's Witness who was trying to pass out material on a street in New Hampshire. And he started to draw a pretty hostile crowd. A city policeman came and intervened, during which time Chaplinsky called him, quote, a goddamned racketeer and a damned fascist. And I know, once again, that is 1942. How the language has grown since then. I mean, today that is something that, people call each other on Big Bang Theory. So really that's hardly anything today. But at the time, saying that somebody was a goddamned racketeer and a damned fascist, well, that was pretty intense. So anyway, Chaplinsky was prosecuted under a state law that banned offensive speech and name-calling in public. It eventually reached the Supreme Court, and the Supreme Court affirmed his conviction and said that there were certain kinds of words, and this was the first time the court used the term fighting words, and they said these were words that by their very utterance inflict injury or tend to incite an immediate breach of peace. So words which by their very utterance inflict injury or tend to incite an immediate breach of peace. And they said that protecting those words was outweighed by a social interest in order and morality. So what they were saying there was that if you're saying something that's so awful that it rises to the form of hate speech or fighting words, it's not protected by the First Amendment. However, later, the Supreme Court further explained, and this is important, that in order for something to be considered fighting words, it had to be uttered in a face-to-face situation, which means literally that you have to basically say this to another person to their face. You know, to use more modern terminology, you have to be in their face. Okay? So in other words, if you just go and stand up in an auditorium in front of 100 people and you start using words, that's very likely not going to be considered fighting words. But if you go down into the audience and go up to one person and start saying those things to that person in their face, pointing your finger, well, then that could be considered hate speech. So there have been examples where, people have thought that, this is too lenient, meaning that the government should be restricting more stuff as hate speech than it really is. For example, there was a Nazi march in Skokie, Illinois, that the city tried to stop, but the Illinois Supreme Court said you can't do that. They basically said that just people marching around with Nazi uniforms and with Nazi insignias was not enough to actually rise to hate speech. So what the court said was just these guys marching down the street, that might be repellent, repulsive, everything else, but it's not actually hate speech. So then another case we talk about is this case of RAV versus St. Paul. And just as an aside here, whenever you see an abbreviation like RAV in a court case, it normally means that that person is a minor, somebody under 18 years of age, and so we don't give their name. Instead, we sort of put their initials. However, we do know that RAV was a person named Robert A. Victoria, and he was a member of a group of teens that burned a cross on the lawn in front of an African-American family's house in the early 90s. The city had an ordinance against expression like this that, quote, arouses the anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. And you don't have to necessarily write all that down. But I do want you to sort of understand that the law very specifically, said once again that it's speech that arouses the anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. What happened when this case reached the Supreme Court was the Supreme Court struck down that law. And the reason they struck it down is because they said that it specified certain kinds of speech but not others. So, for example, they said that, it didn't cover like political affiliation or sexual preference. Because when I gave that list of things there, it said race, color, creed, religion, and gender. It didn't say anything about these other kinds of things that people might find offensive. And so the court said that this was too selective, and they basically struck down the law. And again, the court didn't defend what the kids did, but they basically just said you can't prosecute them under this law because this law is unconstitutional. They did say, for example, you can prosecute them for trespassing and damaging property, which the city did do eventually. Okay, and then we have this idea of intimidating speech. And this is sort of related to the idea of cross-burning. Virginia actually has a law against all cross-burning, but in a court case, the court actually said that the cross-burning had to rise to intimidation before it could actually be prosecuted. So in other words, what they're saying is, theoretically, you could just burn a cross in your backyard if you weren't really trying to, intimidate anybody particularly with it. But if you basically put it in front of somebody else's house or, something like that, well, then that would be intimidating. However, a lot of people thought that this court decision was misguided and that, we didn't really need to add that to the state law. there are a lot of people who believe, and probably justifiably so, that you just shouldn't be allowed to burn a cross. However, again, what the court was sort of trying to say was, if it doesn't rise to intimidation, it's not actually prohibited. Okay, picketing, very quickly for the most part, because picketing is pretty straightforward. Picketing is generally granted very broad protection by courts in this country. And I think the reasons for this are good, because picketing is usually something that is done by people who don't have a lot of power. For example, you never see CEOs or millionaires or billionaires out picketing. I mean, you just don't see it, because they have all sorts of other means to sort of get their messages out and to be heard. However, if you're a factory worker, or you're somebody who's unemployed, or something like that, I mean, picketing is in a lot of cases like the only way that you are going to be able to express yourself and be able to be heard. So generally speaking, the courts protect picketing very broadly. For example, you can't ban picketers from public property. You can't pass laws that prohibit picketing about certain kinds of things. You can't require licenses for pickets. There are even cases where picketing is permitted on private property. Most notably, like in cases of strikes, and you'll see, the picketers outside on strike in front of the company they're on strike for. Once again, they are generally protected and allowed to be there. So we see picketing all around. I mean, we see picketing, about various different kinds of topics. And as I said, picketing is generally very protected. Now, there are exceptions like military bases. There are restrictions in some states about picketing at abortion clinics. And this is usually, once again, in cases where the picketing goes beyond just picketing and becomes action, becomes intimidation, becomes keeping people from going into an abortion clinic, or, attacking them or pushing them as they're going in. I mean, those kind of things. But pure picketing is usually pretty protected by the First Amendment. Which brings us to the case of the Westboro Baptist Church. And you might know Westboro Baptist Church is this church that has been protesting the military funerals of people that have been killed in the wars. And their message, as I understand it, is they believe that our country is being too lenient about gay rights, and that is why God is punishing us by killing our soldiers. So what they've been doing is they've been picketing the funerals of soldiers that have come back, that have been killed. And one of these cases reached the Supreme Court, and the Supreme Court essentially said that, they have the right to be doing this. And the quote here from Chief Justice John Roberts at the bottom, simply put, the church members had the right to be where they were. And so there have been, you are able to put restrictions on them as far as like they're not allowed to be like right there at the funeral service, while the family's there and they're lowering the casket. I mean, they're not allowed to be protesting right there, but they are allowed to essentially be protesting like outside the cemetery or the funeral home where the funeral's taking place. So that's kind of where we stand on Westboro Baptist Church. And that's where we stand on conduct as speech.